thanks for coming, everybody. Thanks for coming tonight. We'll probably have a few more people coming with traffic, but we're gonna get started. So my name's Mike Weller. I am one of the agents and realtors here at the Keller Williams office in Yorba Linda. I've been in real estate about 17 years now. Probably about 5 years ago or so, I met Lalit, who is an estate planning attorney with Bridge Law. It's his firm over in Anaheim Hills. We've worked together a little bit. We've done a couple of seminars before. We did some on Zoom during the COVID era when everything was on Zoom. And he is amazing as far as the way he presents information, the way he takes complex problems and is really able to explain it in a very simple way. So in real estate, I see a lot of people that are homeowners that do not have proper estate planning. They don't have trust, they haven't done their estate planning, and oftentimes it can end really ugly. So I really understand the benefits of appropriate estate planning. So I thought it was great that Lalit was agreeable to come here tonight and share his education with everybody in the room. So before Lalit gets started here in a minute, one of the things on your desk, I just want to kind of pivot here for a second. There is a little piece from something called Brothers on a Quest, which is it's a local nonprofit I am on the board of, and it is it's a nonprofit that is the cause is raising awareness and raising funds for a rare form of ataxia, and even ataxia itself as a disease is rare enough that probably more than half the people in the room have not heard of ataxia, but it's a neurological disease. Brothers on a Quest is raising funds for research on the AOA2 form of ataxia, which there is a woman here who started Brothers on a Quest in Yorba Linda where 3 of her sons have this disease. So it's kind of her passion, and I've gotten to know her over the past 3 or 4 years, and she's asked me to be on the board of this nonprofit, so I'm on the board, and this is me, it's a passion of mine now as well. Just educating people, doing some research on it. They're raising funds at UCLA for this very specific research. So what I would ask is just take a look at that. If Lalit does a great job, if you feel like you got value out of tonight, I would love it if you might go back and maybe make a small donation, but that's totally up to you. But again, it's all depends on how great Lalit does. So with that, I want to introduce Lalit Kundani. No pressure at all. It's all on you. You got it.
Well, good evening and thank you all for being here, and thank you to Mike and the Weller Group for hosting us. I've had the pleasure of working with Mike for a number of years, as he mentioned, and during that time, we've referred a lot of our clients to Mike, and I think what makes them really special personally is the importance of educating their clients. Not all real estate agents do that. Not all of them actually take the time to help their clients understand other aspects of their life. It's kind of a one and done and see you later. And I really appreciate the fact that you're able to, make time for things like this so that your clients and folks in the community kind of learn more about the topics that, frankly, people should be teaching us about, but we're not taught these things until it's too late, as you'll come to see. So I do hope that we have a conversation today, rather than me just talking and not knowing what you might be thinking for an hour. My philosophy when we do these things is to open it up to questions as they come up. You won't forget your question, and I'll kind of know what you're thinking, okay? But by a show of hands, could you just let me know if you already have a trust, just by a show of hands, because I just want to know. I want to know my audience. Okay, and then I think I know the answer to this question, but raise your hand if you don't have a trust. Okay, good. There's no wrong answers. All right. So, congratulate and thank you for being here today, because this is hard, right? I mean, not many people want to be here at 5:30 on a Thursday talking about estate planning, and so I give you credit for at least being in the room to educate yourselves. Probably share that information with your family and friends, because they probably can benefit from what you're going to learn today. My goal during this time that we have here tonight is to make sure that you understand definitely some basic concepts for estate planning, before you leave the room today. I am not here to sell you on anything at all, and I sincerely believe that. I really like educating people. It's a passion of mine. So please relax, ask freely any questions you have, because I really have no agenda other than making sure that you go home today with some knowledge. And what you do with that, that's up to you, but that's the main point of today's presentation. I have tried my best to make this a little bit more lighthearted. It's hard, but as you'll see from the picture, I'm going to analogize kind of what we do in estate planning to the story of the three pigs. I know you all know what that story is, but we are going to go through it real quick. Before we do that, I have to say this because I'm a lawyer, that I am not giving anyone legal advice today. I am going to give you a lot of things to think about, but your situation may vary, okay? So the problem with the law is there's the law, and then there's thousands of exceptions, and then within those exceptions, there's like hundreds of exceptions to those exceptions. Where you fall, I have no idea, right? What I'm going to tell you are generally things that apply to most people, but your individual case may vary, and so just take that with a grain of salt. All right, those are my two girls. Gia's 8, Sonam's 6, almost 6. And when they were growing up, they would love for me to read to them The Three Little Pigs. Now, you all remember this story, okay? And I'm not going to belabor it, but just let's kind of put our minds there. The mother leaves her 3 pigs out into the world and says what? There's something called a big bad wolf, right? And what's significant about that is everybody knows that. It's not like this, maybe there's a wolf. Everybody knows there's this thing called the wolf out there. And what each of the 3 brother pigs do is up to them, right? And we remember the story, the first one builds the house of straw, and the other one builds the house of sticks, and the other one builds the house of bricks. And we all know the story that the wolf puffs and puffs and blows all the houses down except the house of bricks, okay? So we're gonna use that today. It's kind of an analogy to sort of follow along when it comes to estate planning, what we do. So I thought this was gonna be a good way of talking about it because we're gonna learn, all of the above during this talk, okay? Now, I did say and I did mean that if you have questions, feel free to raise your hand and ask them. If for some reason I ask to just hold your question, it's because there's probably a slide about it and I'm just gonna wait for a more logical time to get to it, but feel free to ask anyway, okay? So, we've divided today's presentation into 5 chapters. The first chapter we're going to talk about is something called the probate wolf. And you cannot understand what a trust is, you cannot understand what a will is, you cannot understand estate planning until you understand what a probate is. Please raise your hand if you have ever dealt with a probate. Consider yourself very lucky, except you. Consider yourself very lucky. Probate is one of the worst things known to man, if and especially if you are in California. Okay? We're going to talk about that. So here's our wolf. We're going to call this the probate wolf. In California, if I die, not if, but when, right? But when I die, there is something known as probate when I die. What that is it's a court that is set up in every county in the country. And the closest one to us is in Santa Ana. And a probate court is ready so that when I die, the job of the probate court is to do 2 things. Number 1, make sure that all of my creditors have been paid. That's job number 1. Job number 1 is not to figure out who gets my assets. Job number 1 is not to make sure my kids are safe in a home that they can continue to use. Job number 1 isn't to make sure my spouse gets what she's entitled to. Job number 1 in a probate is to make sure my creditors get paid. first and foremost. Now, you might say, well, what's a creditor? Or you might say, well, my home's paid off. Who's my creditor? We all have a creditor. Every single person in this room has at least one common creditor. Anyone want to guess what it is?
State of California.
State of California, actually there's two answers. State of California is one.
And IRS.
The IRS is two, correct. Very good. Why are they creditors? Because, as Benjamin Franklin said, death and taxes are inevitable, right? When I die, we're what, March something, right? Something? If I die today, the IRS says, we're sorry, but your taxes are still due next April. April of 2024, my family has to pay my taxes next April. Why? Because I may have generated income from January 1st to today, and I'm still responsible for paying that when I'm dead. Not only that, my estate will continue to make income after I die. I might have a retirement account, I might have a rental income, I might have brokerage accounts. There's income being generated after I die. And that income is also due the following April. So probate court is established to make sure that all of my creditors have been paid. The IRS, the state of California, courtesy of the Franchise Tax Board, but it could be my mortgage, it could be a loan, it could be insurance, it could be my utility bills, my cell phone bills. It could be anything under which I held my name. Anything and everything that I put my name on, that I signed for during my lifetime, has to be cleared in a probate court. The probate judge literally will not transfer my assets to the next person unless and until my debts and obligations have been paid off first. Number one. Number two, after my debts and obligations have been paid off, then the court goes to number two, which is, now I will decide, the judge says, now I will decide who will get whatever is left. And that could be my family, that could be other people, we'll talk about that. But that's job number two, only after job number one is done. Okay? Now you know what a probate is, and you're gonna have a bunch of questions. Does this apply to everyone? Does it apply to me? What if I own my property jointly? I'm gonna answer all those questions, but I just wanna go step by step. That's what a probate is. Who does it apply to? Let's start with that. In California, it applies to those people who have property worth more than $55,000. That means if you are a homeowner, you will have a probate when you die, because very rarely, and Mike will tell us this, are we gonna find property valued at less than $55,000 in California, okay? By the way, some people might say, well, what if I don't have that much in equity? What if I purchase my home and I refi, and I don't even have $55,000 in equity? Does that apply to me? What's that 55 based on? And of course the answer is, it's based on fair market value. That means you could have $1 of equity in your home. You would still have a probate, because if your home, if the street value is worth more than $55,000, you're in the probate bucket when you die. Okay? If you do not own a home, if you are a renter, or you haven't, you don't own your home, you live somewhere else, then you will have a probate when you die if your collective assets, bank accounts, brokerage accounts typically, are worth more than $166,000 on the day you die. Okay? So those are generally the two categories of people who the probate net is going to apply to. You say, okay, maybe I'm in that bucket. What else is bad about probate? What's so bad about it, actually? Well, here's one thing that's terrible in California. Terrible. 1 to 2 years it takes in California to actually close a probate. Okay? Now that's an estimate, but what I want you to understand is this: what makes California kind of unique compared to other jurisdictions, other states, is that California, it's not that just, well, look, my family comes into probate court and says, how much do we owe? All right, we paid the IRS, here's the check, here's the check. We paid all the creditors, now give me the property. Can we just get this done in a day? It's not that simple. California not only has a very long line when it comes to getting a court date, 3 months usually in Orange County just to get a court date, 6 months in LA County just to get a court date. But the thing that makes the California probate very unique in a bad way is they say that you can't just close a probate just because there's no creditors. Because the probate court says, state of California says, what if there's other people out there that don't know that you died? What if you owed someone out there money, but they just don't know that you died? How would that unknown person know to come to probate court and be heard? I mean, logically that makes sense. But the problem is, because of that, California requires someone in your family called an executor, that is the person who is responsible for handling your probate. The executor has to now go out and put something in the newspaper to say I, or to say I, so-and-so, and the executor, and John Doe has died. And because John Doe has died, we're putting this in the newspaper to let the world know that there's a probate open for John Doe, and we're gonna keep publishing this in the newspaper for whatever the court requires, which, Elena, I don't know if you recall how long that is, but it's like, 6 to 8 weeks, I think, at least a couple of months, okay? So this has to be done in the newspaper. By the way, there's a paper for this. The executor has to put up a bond. They have to put money up to be your executor, so it's money out of their pocket. They have to have fairly good credit to get that bond, okay? And it gets worse. 5 to 15%, that's my number, my average, in fees. This is not money that's going to your creditors. This is money that you're gonna lose in the probate to pay for the probate. So you could lose a lot more just for the creditors, but you're gonna lose for sure a minimum of 5%, maybe more. These numbers are minimums. People have lost 40%, 50% in probate. So it's not free, is the take-home message here. During this time that your family's literally waiting for the probate to be over, your assets aren't gonna be able to be transferred. Your home is not gonna be able to be sold. Your spouse or your child is not gonna be able to refi your home. They won't get access to the brokerage account or the bank accounts. They're locked out of it for a very long period of time. You already know this. Creditors are gonna come before your family. And here's the worst part. At the end of the probate, it is the judge who will decide who gets what I call the scraps. Okay, so to analogize it, think of probate like a big shredding machine. Your assets go in, the scraps come out. It takes about a year to go through that machine. When the scraps come out, it is the judge, by operation of law, who will decide who gets what. And that is called, if you want a legal term, that's called intestate succession. All you gotta know is the judge decides who gets what's left. This is your classic probate. So, if we don't do something about it, this is what we have to look forward to, what your family has to look forward to. So, let's now apply our story to these set of facts. I call this the do-nothing plan. This is the first pig. Okay, this is the pig who says, I'm gonna build my house of straw, right? I got this. And I've seen this come up in 3 ways. In our office, by the way, Elena's in the back. Jyothika's in the back. Elena's our client service director. Jyothika's our legal assistant. We can answer any questions you have, by the way, but they will tell you this, that the do-nothing plan, the house of straw, you will see this come up in 3 ways. Either somebody owns their asset individually. That is a house of straw. The wolf is gonna blow it down, you'll see in a second. So if you own an asset just in your name, you gotta be careful. The other way we see this is people who own their assets jointly. That's a lot of people, a lot of married couples. Oh, we own our bank accounts jointly, we own our property jointly. They actually think that they're doing the right thing. We're not gonna own it in just one person's name. That doesn't sound like a good idea. Oh, I know, we'll own it jointly. That's the thought at least. Okay, that might be good in some ways, and you'll soon start to see that that's gonna be a problem. The third way we have a house of straw is a lot of people go, aha, I know, I'll go one step further. I'll jointly own my assets with my spouse, and we'll put beneficiaries down. Because I know, I've been told that as long as we have beneficiaries on the account, that when we die, it's gonna go to the beneficiaries, so I'm done. You following, right? Everyone's following? Okay, so we're gonna go through each one of these, and we're gonna see how this holds up. Individual ownership. I don't even have to explain this. I just got finished telling you with probate. You die, that means no one else owns your asset, it was just you. There's no beneficiaries, that's what we're talking about. So if I own an asset just in my name, nobody else is on the account, nobody else is on title, and there's no beneficiaries. When I die, 100% probate. Everyone got that, right? Any questions about that? Okay. Joint ownership. What's so bad about joint ownership? So let's go behind the scenes and let's figure this out. First and foremost, there are different types of joint ownership. So what I'm about to tell you is very real estate specific. So truly the only person in this room who will truly appreciate this is Mike. But I want to share this with you, and Mike would want me to share this with you. So I'm going to do something which I don't really do for a lot of people, but because we are where we are today with Mike, I'm going to do this. Elena pulled today a real deed. We changed names, we don't have to, but we did. And I want you to look at this deed. This is a real, I want to show you what really happens. I'm not making this stuff up. This is a real deed. And what it shows is that the title was taken in the name of John Doe and Jane Doe as husband and wife, okay? John Doe and Jane Doe as husband and wife. So those are real names, we just took them out. But here's my question to you. That's joint ownership, right? That's joint ownership. So here's the question. When John Doe dies, when the husband dies, who does it go to? It's not a trick question.
Jane Doe.
It goes to Jane Doe. And you would say it's because they own it jointly. And you'd say, and some people would say, of course she'd get it because she's on title. Or some people would say, of course she gets it because they're married and they live in California. I know California's community property. A lot of people will say it's gonna go to the wife, okay? You're not wrong. It goes to the wife. But here's the more correct answer. It goes to the wife after probate. And people go, whoa, 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 no, it's jointly owned. Isn't it true that when it's jointly owned, it just goes to the spouse? Yes, if title was taken correctly. What's wrong about this deed is that it just says John Doe and Jane Doe as husband and wife. It does not say how or what kind of joint ownership it is. It just says a relationship, but it doesn't give a legal description as to what the legal relationship is of their ownership. I know I sound like a lawyer. I didn't make this up, right? I didn't make this up, but I have seen this happen time and time again. And as much as I would love to have you come into my office and charge you to fix these things, I would much rather you not make the mistake to begin with, okay? It's about educating our clients. It's about educating our friends and our family. So I want you to understand this. I want you to look at your deeds. Here, and I'm gonna tell you how to fix it. Here's the problem. Now we're gonna get into legal 101. We're gonna go to law school for a little bit, and I'm gonna get out of law school, I promise, okay? Tenants in common. This is what it means. Tenants in common is a form of joint ownership. There's different kinds of joint ownership. Tenants in common is one kind of joint ownership between 2 people, 3 people, 4 people. What a tenancy in common is that when John dies, the property does not go to Jane. Perhaps John and Jane are brother and sister. Perhaps John and Jane are 2 friends. Perhaps John and Jane are father and daughter. What they're saying is, when I die, you're not going to get it, because my share, John's share, is going to go to other people. It's going to go to my kids. It's going to go to my spouse. It's going to go to people I want it to go to. I don't want it to go to you. And similarly, Jane, if you die, it's not going to come to me. It's going to go to whoever you want it to go to. We call that a tenancy in common. Okay? Make sense? The problem with tenancy in common, I want to be careful how I say this. Sometimes it's going to be used, and sometimes, and a lot of times it's not going to be used. But one of the problems with tenancy in common is this: that if your deed says tenants in common, and you didn't want it to be tenants in common, that's a problem. The problem with what I just showed you is that it didn't say tenants in common, it just said husband and wife. Well, the law says, California says, if the deed does not say what it is, it's presumed to be a tenants in common. I'm going to repeat that. If your deed doesn't say anything as to the legal relationship, it's presumed to be tenants in common. What that means now is this crazy result where when the husband dies, even though the wife is alive, it's going to go into probate. You see that? Horrible, 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 horrible result. True story. Happens all the time. And now we're going to go full circle, and I wasn't just trying to put a plug in for Mike. I really mean this. This is why real estate agents need to educate their clients. But not all of them do. That is a real deed that some person put together after a sale. And that person should be sued, frankly. They're not going to be, but that's where the problem lied. It was when the property was purchased. You don't know that. They give you a stack of documents this big. Just sign, 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 sign. Right? So educate yourself, work with right people. I mean, that's what I guess that's one thing to take away from it. Okay. I'm going slow, but I'm going to have to speed this up. So, here's another one, okay? This is another one. This is a real one, okay? We're actually in court on this one. We changed the names. This one, the child was on the deed. That's always a bad idea. You'll see that in a minute. Child and mom and dad, but see now here it says all is tenants in common. At least that one, at least this one says it. But that's bad, because what happened here is, was it the mom?
The father.
The father died. The father died. Now you would expect that the father's share should at least go to his wife, or at least to the wife and the child who's already on the deed. But no, it says tenants in common. So there's a probate. The family has to go through probate because 1/3 of the property is now going to probate. Okay. So there's 2 other kinds of joint ownership. Something called joint tenants and something called community property with right of survivorship. Both have something in common. They both have this in common, where if John dies, his share is going to go to the other person. His wife, his sister, whoever that person is, and it could be more than one. It could just, if it's 3 people, it goes to the other people. That is called a joint tenancy. It's also called community property with right of survivorship. Community property with right of survivorship applies only to married couples. Joint tenancy can apply to married couples, but it can also apply to those who are not married, okay? But what they have in common is that one dies, it goes to the others. What's the difference between the 2? There's a big difference between the 2, a subtle one that most people won't know, one that most people won't tell you, and you are gonna come out 100% better because you were here today. Here's the difference. I'm gonna save you a bunch of money. I wish they taught these things, they don't, okay? Capital gains, just a recap. What is a capital gain? A capital gain is you buy a property for $250,000. Let's call it your basis. That's the legal term, right? That's your basis. How much you put down for it. When you sell it for $1 million, that's the fair market value. You would say, I've sold it, it's now worth $1 million. When you sell it, what happens? Capital gain is fair market value minus the basis. I sold it at $1 million, I bought it at $250, I made $750,000 in gain, profit. I have to pay tax on that profit. That is called your capital gain. Okay? It's probably more than that in California, but we're going to assume a third, okay? $250,000 in taxes. Everyone following so far? That's capital gain 101, right? Okay, what happens at death? This is where you're going to see the difference between joint tenancy and community property with right of survivorship. In joint tenancy, husband and wife own the property equally, let's assume, right? So the way to think about it is if they pay $250 for it, the husband's part of it is $125, and the wife's part of it is $125. And when they sold it, his share is worth about $500 and her share is worth about $500, right? This is kind of how we think of things when they're jointly owned. Now, let's say the husband dies. When one spouse dies, only their basis steps up to fair market value. So here's what happens. By operation of law, when the husband dies, his basis in the property, which normally was $125, is now considered to be $500,000 because he's dead. So when he dies, the IRS says, we're going to give you, the wife, a break. We're going to consider that his basis is no longer $125. We're going to just say it's $500 because that's what his basis was worth at the time that he died. Your basis, they say to the wife, your basis, because you're still alive, is $125. So the total basis, if she wants to sell the property, so his basis goes to $500, her basis stays at $125, the total basis for the property is $625. So if she sells the property when it's worth $1 million, let's say he dies, and she says, well, I want to sell the house, she is going to pay capital gain. She's going to sell it at $1 million, but instead of going $1 million minus $250, it's now going to be $1 million minus $625. So her gain is reduced to $375. Her taxes are reduced. She doesn't have to do anything to do this. This is just going to happen. It's called the step up in basis. Okay, it's still valid law in the United States. This across all states, this is true. You die, your basis steps up to fair market value, your spouse sells, or your kids sell, there's less tax owed. So, are you guys following so far? Okay. Compare this to what we're about to see, which is community property with right of survivorship. Here's community property with right of survivorship. Husband dies. When one spouse dies, both spouses get a basis step up. So, husband dies, only his basis should go from $125 to $500. The wife should actually be the same because she's still alive. She hasn't died yet. But because they held their title as community property with right of survivorship, not only will she get the house when he dies, but she'll also get a full second step up on her share. So now the basis is worth $1 million. If she turned around and sold the property after he died, she would have no gain, zero. All because they took title the right way. Amazing, isn't it? So, hopefully, you all will at least use this to check on how you own your home. Because if you have it as joint tenants, here's the good news. It can be changed. Okay? And then you qualify for this. Now, maybe this will never come up, but if it does, what did it cost you? $100 in recording fees? Okay. So, either way, if you, let's say somebody said, okay, I'm gonna keep my property as community property with right of survivorship. Okay, I follow that lawyer, okay, I think I'm gonna do that. Well, is this still good? No, you're still under a house of straw. Why? Because when the husband dies, he goes to the wife. Great, she gets a good nice step up. She sells the house. But when she dies, there's still going to be a probate, isn't there? Because we're all going to die at some point, so there's still a probate at the end of this. Secondly, incapacity is always going to be an issue. Now, I'm going to tell you a quick story now, so that later when we see it, we're going to go right through it. This is a true story. I like telling true stories because people relate to true stories. I had a client, a family that we represented years and years and years ago at another firm. And the facts were very simple. A man and woman were married, they had 2 adult daughters. One was in medical school, one was in law school. He was in his 60s, he was about to retire, probably about a year away from retiring. And he worked at a company in Whittier, and he was at Colima, I think it was, and he was stopped at a red light. Now, mind you, he did not have an estate plan, but all of his assets were owned jointly with his wife. Okay? So in a worst case scenario, he dies, everything goes to her, no probate, at least at that point, right? You follow it, right? Well, here's the problem. There's a truck behind him going down Colima, loses controls of its brakes, rams right into the back of his car, pushes him in the middle of the intersection, and it's about an 8-car collision on a Friday at 4 o'clock. Unfortunately, this man survives the accident. He probably should not have survived that accident, but he survived. He was in a persistent vegetative state for, I think, 6 to 7 years. Our law firm was able to get him a substantial, though it's never enough, settlement from the company, the trucking company that caused this injury. It was in the tens of millions of dollars. Guess what? The insurance company, knowing that he's completely incapacitated, can't speak, can't talk, can't walk, can't communicate, can't eat, can't do anything, has to, by law, issue him a check in his name, because he's still alive. So this woman, his wife, is literally holding a very large check, which she cannot cash. Why? Because it's in his name. So what does she have to do at this point to cash this check? Can she go to the bank? Nope. Can she sign for him? Nope. Especially under the eyes of 20 lawyers who issued her this check. What she has to do is do what's called a conservatorship. She has to go into court and get legal ability to sign this check for him. The minute she does that, the court is going to watch her. Are you going to take this money and run? Are you going to take this money and leave your husband? Because the court has an obligation to make sure she uses the funds for him. By the way, she can't speak to his doctors. She can't make medical decisions for him because she's not him. You've all heard of HIPAA. Okay? It gets worse. Her 2 adult daughters, one's in medical school, one's in law school. Guess what? They got a lot of bills to pay, right? Plus, he can't go upstairs. They live in a 2-story home. She's like, I want to sell the home. I'm using the guest room downstairs, but this isn't sustainable. Can I just sell the home? She can't sell the home. Why? It's jointly owned. And Mike will tell you. Because if you go to Mike and you're jointly owned, and she went to Mike and she goes, Mike, I need to sell the home. We're ready to sell. He goes, that's great. Except I need your husband's signature to sell this home because it's jointly owned. Who thinks of these? Who plans for these? Who tells us these things? Nobody, until it's too late. So she had to open a conservatorship, pay thousands of dollars in attorney's fees, and had to do it for 6, 7 years, going back to court because the judge doesn't trust her. And she's the only person standing next to this man. And she's treated almost like a criminal. Okay? How could this have been avoided? A trust, powers of attorney, you'll see, but it's all about how you take the title from day one, especially real estate. So, what I'm saying is, people go, oh, let me back up. My point of saying this story was this. I hear a lot of people tell me this. Oh, we'll just add people to the deed. We'll just add people to the deed. We'll just add our kids to the deed. Well, what happens when one of them gets incapacitated? Just one. You just heard what happens. So people think like they've beaten the system. Oh, I know, we'll add people and we die, we die. But what happens if you don't die? You didn't bet on that one, huh? Okay, never add your non-spouses to your assets. What I mean specifically here is, don't add children to your property. Please don't do that. If you're gonna do that, please go through a lawyer or an advisor or somebody who can at least evaluate for you if you need to do that. There's never enough time, guys, but I'm gonna just go real quick. I'll just say this. It's gonna increase your liability. This is common sense. If I add my 18-year-old boy to the property, to a $2 million property, and my 18-year-old who's just been driving for a year and a half gets into a terrible car accident and gets sued, guess what? He's on title to my home. Guess what? That person's coming from my home. And I could be kicked out of my home in that lawsuit. So liability for you when you add people to your title. It could be your brother. He gets a divorce. It could be your sister. You've seen it all. Don't add people on your title unnecessarily, thinking, oh, it's gonna somehow work around probate. No, it's gonna cause more problems. More than that, it increases their taxes. I'm not gonna talk about that because I have a lot of things I want to talk to you about, but just take my word for it, and if you want, we can talk after, and it's actually probably in your slides. Okay? Now, let's eliminate joint ownership. It's just not good. There's too many things that can come along with it. What's the problem with beneficiary designations? People go, well, I put beneficiaries on my asset. What's wrong with that? Okay, so let's go through that. Incapacity is still an issue. I think we just covered that one. Let's go back to that client of mine, the husband and the wife with the 2 adult daughters, one in med school, one in law school. He could have put all the beneficiaries he wanted on his bank accounts. He's still alive. Beneficiaries only get paid when he and his wife die. Okay? So just because you've thrown beneficiaries on your account doesn't mean you've solved for incapacity. You get incapacitated, it's a problem. You're incapacitated, you can't get into that bank account. Your beneficiaries can't get into that bank account either, because you're still alive. People sometimes name minors, minor child, as a beneficiary on their life insurance, on their retirement account. I think it's malpractice. I think life insurance agents should never let that happen. I think retirement financial advisors should never let their clients name a minor child as a beneficiary. But I don't make the rules. The problem with it is when you die and it goes to that minor child, it doesn't go to the minor child, because the minor child can't inherit until they're 18. So now it goes into probate court. It's called guardianship of the estate. It's not called a probate, it's called guardianship of the estate, but it's probate court. And it's a delay for years. Somehow this is still legal. Okay? So don't name minors as beneficiaries. We'll get to some of the other ones, okay? So, okay, this is probate. House of straw, try to avoid it if you can. Okay, let's go to the house of sticks. We have the second pick, the older, I don't know, was the older brother, the other brother? He was the smarter than the other one, right? He goes, no, you can't do a house of straw. That's gonna get blown down. You gotta think more. You gotta do more. You gotta work a little bit harder. And this pig, to his credit, took the time to do something better. I don't think we give this pig enough credit, actually. Now, he gets blamed a lot in the story. Oh, you built a house and got blown down. Yeah, but he actually did better than the other brother. He thought about it. He did think about it. He goes, no, that's not gonna work. I'm gonna do something better. Okay, so it's true. A house of sticks is better than a house of straw. But in this example, our house of sticks is something called a will. And too many people know too little about what is the difference between a will and a trust. A will is a house of sticks. a trust is a house of bricks. And I'm going to show you why. But I want you all to understand this point. That a will and a trust are two different homes. They're made of two different materials. And one is far superior than the other. Without question. Okay? Without question. It's not even a debate. The confusion, as you will see, is due to a lot of reasons. But first and foremost, I always want to say I give people credit for doing the will. Because that means you at least thought, oh, I can't do nothing. I can't do beneficiaries. I can't just do a joint ownership. I got to do something. So a lot of people, millions of people in America, go out and they go, I got to do a will. Maybe they see a lawyer. Maybe they go on LegalZoom. Maybe they find a way to do it. But they do it. A lot of people do wills. And a lot of those people think that when I die, it's going to go to the people in my will. And that's true. Except, you got to go through probate first. That's the part they don't tell you. You got to go through probate first. After probate is over, 1, 2 years, 5 to 10, 15% is taken, creditors have been paid, the waiting period's done, the executor put up a bond. After all the misery is over, if there's scraps left from the shredding machine, those scraps will go to the people in your will. Is it better than the judge deciding who it goes to? Yeah, that's why it's better than a house of straw. But it's still subject to probate. It's still going to be blown down. Because you still got to go through probate for that will to work. Now, we can ask all day long, why do people create wills then? And I have a theory. I have a couple of reasons why. One, misinformation. Probate is state specific. New Hampshire has its own rules than California. New Jersey has its own rules than California. If you die in New Jersey, and I know New Jersey because I have relatives in New Jersey, I have lawyer friends in New Jersey. If you die in New Jersey, the probate is, anyone? How long? 2 weeks.
Wow.
2 weeks, unsupervised. 1% is what I've been told it costs to do a probate in New Jersey. Because probate is so quick and so inexpensive and so easy, people are okay with probate. And therefore, people are okay with wills. Yeah, it's going to be a probate. My will will tell who goes after probate. What do I care? California, it's a different story. So if you talk to your brother in New Jersey, he goes, I just do a will. Or Aunt Susie died in New York and it was fine, doesn't mean it's going to be okay for your kids in California. Misinformation. Doesn't help that we have Google, because you type in any article today and what do they all say? Done your will yet? It's time to do your will. Don't forget to update your will. Will. Maybe for New Jersey, pretty bad for California, and I'll tell you a secret, and this is bad on my profession, a lot of lawyers in California want you to do wills. Well, they're nice to do a will. Do you know why? Anyone? Because they get paid twice. You know what a lot of these lawyers do? So I've heard. Just do a will. Okay. I'll charge you a little bit for the will. And I'll keep your will for you in case something happens, your family can come to me. They get paid twice. They get paid on you to do the will. And then they get paid on the probate. And you know that 5 to 15%? California writes it into the law how much the lawyer takes of that. Half. Whether you like it or not, we get half of it. I don't even have to be good. Probates are great. Mike and I were talking about probates earlier today. I don't do a lot of them, thankfully. But you know, one of the good things about a probate conversation, I don't have to quote my fees. California will determine what I get, whether you like it or not, or I like it or not. It costs far less to do a trust. We make more in probates as lawyers than we do writing trusts. Okay? So you want motivation, there's your motivation. Okay. Does that make sense? Everyone understand the will? Okay? Now, I'm probably gonna confuse you a little bit. I like to do that, but I'll do it a little bit later. Okay, so a trust, what is it? It is a will. It's kind of like a will. Actually, it's what you think a will is supposed to be. Here's who gets what when I die, without it going into probate. That is what a trust is. Right? I'm obviously simplifying the definition, but functionally speaking, that is what you want. Is you want to avoid these problems. If I die, I don't want to probate. If I get incapacitated, I don't want my family to go and get a conservatorship. So I can do a trust, and I can sort of deal with these issues. And the trust can do all of the following. Different trusts do different things. We could spend 2 hours talking about all the different trusts there is, but I'm just building a foundational story for you that a trust is the house of bricks that you really want to focus on. What is it? I compare it to a wagon, and that's my daughter, that's my younger daughter. And no one's gonna, my wife will agree with me when I say this. She falls everywhere she goes. She runs around the house and she falls, and she's carrying her toys and they go everywhere. Everybody knows that about my younger daughter. That is probate. It's where you're sitting around with assets in your name and you're running around and you die, it all goes everywhere. That's probate. A trust is if I told my daughter, put all your stuff in a wagon, pull the wagon everywhere you want around the house, and if you fall, the assets are still in the wagon. That's a trust. That's all a trust is. It's a hold, it's a container. So that when you die, everything is in your container and not in probate. And your trust says who can deal with your container after you're gone. That's all a trust is. In fact, here's what it really looks like. Here's the toys, my daughter's toys. It goes into the trust. That's the key, by the way. It has to be titled in the name of my trust. Now, you, because you created the trust, you put your assets into the trust. So you're called what's called a grantor. You're also somebody called the trustee. You get to pull the wagon wherever you want. You get to control how the toys are used. You can give away the toys and sell them and use them and double down on them and put more in and take some out because you're the trustee. The trustee is who's in charge of the toys. Once the toys are in there. You are. You put the toys, you control how the toys are used, your assets. You're the beneficiary. The toys still belong to you. At no point have you given up your right to do the things that you put into your wagon. We call this trust a revocable living trust. So a trust where you have full control over everything is called a revocable living trust. Revocable, you can change it, you can modify it. Living trust, you created it while you're alive, and you are all of these people. You are the grantor, you are the trustee, you are the beneficiary. Okay? We call this revocable living. You've not lost any control. All you've done is to avoid a probate. You've retitled your assets into the name of your trust so that when you die, it's in your wagon, not in probate. Here's the one thing, probably the most important thing you will take from this as far as trust is concerned is this point. This is the biggest mistake people make with trusts. They don't fund it. Funding a trust, you have to understand what this means, is the most important thing with a trust. Let me give you another analogy. Say we have a box, an empty cardboard box, and they put it right here on a table in front of you. That is your trust. When you sign your trust, you and your spouse come into to the lawyer's office, you sign the trust. The lawyer at that point has done nothing more than created an empty box for you. And the lawyer is going to now say to you, good luck, see you later, bye, take your trust home. And you walk around with this empty cardboard box, and your whole life you're left thinking, well, when I die, all of my assets are going to not go into probate because I created this trust. But you've got to look down at that empty box and realize it's empty. It is your job to go to your banks and your brokerage companies, and if you have properties, and it is your job to make sure that before you die, you change the title of your assets so that the trust is the owner of your assets. We call this funding. It's really retitling your assets. And you must make sure that if you get new assets, which you will, that you obtain the new assets and put them in your trust or keep it titled in the name of your trust. Here's the problem. If you die and there's something still in your name, it is going to go into probate, even though you created this trust. Let me repeat that. If you create a trust and you put 9 assets in your trust, 9 assets are titled in the name of your trust, but when you die, there's 1 asset that you left in your name, this 1 asset will go into probate still, because it was in your name. Creditors, all of the things apply now, because you owned it when you died. So it is imperative to make sure that before you die, you need to transfer your assets to your trust correctly. There are some things, I'm not going to get into it today, there are some things that won't go into your trust for tax reasons. But for the most part, almost everything else, except for the exceptions, will go into your trust, should go into your trust. So I want you to understand that you will still have situations, we still see situations where people die and there's a probate, even though the family created a trust. And that's the reason why. And by the way, I told you like 5 minutes ago, I was going to confuse you. Here's what I meant by that. In that scenario where this 1 asset did go into probate court, even though you created a trust, now you need a will. Now you need a document to say who gets the scraps. Because now this is going to go into probate. I can't stop it. Trust isn't going to be able to prevent it. It's now in that 2-year shredding machine. You just got to wait. Your family's going to have to wait. And when the scraps come out of that shredding machine for this 1 asset, you do want a will in that scenario to say, put it back into my trust. Judge, give it back to my trust. And that's called a pour-over will, by the way. Okay, so you should do a pour-over will. When we do a trust, we give you a will. You don't need the will. You shouldn't use the will. If you're using the will, that means something, that was a mistake, right? But it's there as a backup. Does that make sense? Mike, how are we doing on time?
We're just past 6:30, so you're,
I'm good.
I mean, we don't have, nobody else is coming in the room, so we're,
I want to cover enough topics.
Yeah.
I just don't want to spend too much time on one topic, so apologize. So
you're good.
I do want to talk about this really quick. I think this is important, and I'm going to fast forward some of the slides, and I'll just take questions. And that might be the best thing. So here's another thing that I think I see in trust that I don't like, and I think most people don't like once they understand it's in their trust. A lot of lawyers, and frankly, pretty much all of the legal Zoom, it's like off-the-shelf trusts. And the problem with it is this. One of the problems is this. So you have your box, right? This is your empty box, but okay, they did the funding. They put their assets in the trust. Great, they retitled their assets. Wonderful. There's no probate. So then it says that when the husband and the wife die, it goes to the 2 kids, right? So it's going to go to the 2 kids. So in this example, for this mature daughter, she's going to get her share immediately, right? But then for this clown, okay, we're gonna wait till he's a little bit older. At 25, when you're 25, you son, you can get your share. But we want you to be a little bit older. That's good. That's a good way of thinking about it. But here's the problem for both. In my opinion, this could be done a lot better, because what's going to happen, or could happen, are a number of things. Let's say the son has turned 25. Let's say the daughter, okay, she got her share, right? So now they both are walking around with these assets. These assets are titled in their name. These assets are titled in their name, right? The trust is now gone. They avoided probate. Great. They avoided probate. If that was the goal, that was a success. But could we do better? And what I mean by that is this. What happens when daughter gets married and gets a divorce? That inheritance that she received perhaps 50% of it could be lost in the divorce. I say perhaps, I'm not gonna get into it, but statistically speaking, in California, most inheritances, statistically in California, most divorces involve inheritances that go to the spouse. Legally, it's not supposed to. Practically, it almost always happens. I'm not gonna talk about the reasons why now. So, but I want you to know that in this scenario, even though probate was avoided, which is great, you could have any number of these issues happen. A divorce, lawsuits, means your child gets sued, maybe they're a doctor, maybe they're, whatever. Creditors, they get to a car accident, they get sued. That money's gonna be lost, perhaps. Okay? Not only that, that's during the life of the child. So while that child is alive, these are some of the problems that could happen to the child. Remember, we've beaten probate. I'm moving on. But here's the other thing, and this doesn't always matter, but sometimes this does matter. At the death of the child, now we have to really fast forward, when these two people pass away, and perhaps they leave assets to their children, you could have a probate if she took her money and just kept it in a bank account. Or if he took the money and didn't have a joint owner on it, no beneficiaries, he's gonna have a probate when he dies. Perhaps, who knows, right? We don't know. But there's something called estate taxes. When she dies, there could be estate taxes when it goes to her kids, and when he dies, there could be estate taxes when it goes to his kids. So there is another way that you can leave assets to your children in the trust, where instead of the child getting the asset, where instead of the child getting the inheritance in their name, rather your trust splits off into two trusts, one for each child. The benefit here is during the life of the child, there is protection from divorce creditors and lawsuits. And when the child dies, there is no probate because it's sitting in a trust for the child always, and it's not subject to estate taxes when the child dies. That's a lot of information. I just want you to footnote it. When you go to looking at creating a trust, ask your lawyer, hey, is there a way that we could do this? And you have a slide, and that's sufficient for now, because I want to keep going. I'm going to skip irrevocable trusts. We're not going to talk about this today. Incapacity, we talked about it. So here's the other problem, just to recap. That, by the way, that is the actual picture from that accident. Well, okay, so you have to avoid incapacity. How do we avoid incapacity? Yes, a trust helps avoid incapacity, but in addition to that, you have to, in your estate plan, by the way, estate plan is the binder that the lawyer gives you. The trust is one of the documents in that binder. The other documents in that binder are things like this: powers of attorney, healthcare directives. So let me just briefly tell you what those mean. A power of attorney is a document you create today where you say, who can make financial decisions for me if I'm incapacitated? It's as simple as that. Had that client of mine, before that car accident, he could rewind time, just even for 20 minutes, I guarantee you in that 20-minute span, he would have gone to a lawyer and said, give me a power of attorney. I'll sign it right now. All I have to do is say, my wife is legally able to make financial decisions for me. That's a power of attorney. And a good one will have backups to her. My child, my friend, my brother, here's my order of choices. That's it. Had that document been signed just a minute before that accident, his wife wouldn't have had to open a conservatorship. She could have signed that check. She could have handled all financial decisions. She could have sold the home. She could have done a refund. But she lost 7 years of her life because that document wasn't signed. Similarly, a healthcare directive. It is a document where you can sign today that says, this is what I want to happen to my body. This is what I don't want to happen to my body. If I'm end of life, if I'm in a coma, if should my organs be donated, blah, 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 blah. And it also says, these are the people you can speak to if you, the doctors, need to speak to anyone and I can't communicate, first choice, second choice, third choice. And in those 20 minutes, he could have signed those documents. These are simple things to do. Important, but simple. Okay? If you have minor children, you need to also name guardians for your minor children. That is not something a trust does. A trust does not name guardians for any minor children. If you don't name guardians for minor children, I'm gonna skip this. If you don't name guardians for your minor children, then when you die, your minor children, because they're under 18, have to be raised by somebody. And if you haven't put down on paper who those people are gonna be, the judge decides, not the probate judge, the family law judge. There's another court for that. Imagine the misery if you have all of these things going on after somebody passes away. Your family's like jumping into courts. Oh, I got a family law court. That's to decide who's gonna raise, Jody and Sally. And maybe it's your family, maybe it's not. Okay, so you always gotta make sure that that's done. Okay, I'm gonna skip a lot of this and we're gonna talk about the estate tax and then we're gonna take questions. Okay, I want everybody to know this. This is not talked about enough, in my opinion. And I just need about 10 more minutes and then we'll wrap it up and take questions, okay? There's a lot of material in your slides. Feel free to read through them later, but I want to cover this topic. Raise your hand if you've heard of estate taxes or death taxes, just by show of hands. Okay, good. Some people have heard of it. Here's the common misconception, and this is, sorry? I'm sorry, did someone say something? Oh, question? Was there a question? Oh, okay. I want everyone to kind of know a little bit about how this works. Separate and apart from probate. So I'm not talking about probate anymore. Separate and apart from probate, there is this thing out there called the estate tax. Think of it like another wolf that you have to worry about. The estate tax in California is, the only estate tax that you have to worry about in California is the federal estate tax. California does not have a state estate tax.
Yeah.
Okay? Yet and not anymore. So it has had it, I think, 4 times, and it's been repealed, and it's come back, and it's been repealed, and it's come back, so it's just a matter of time. So you are right, not yet. The federal estate tax, still you should understand. And this is my pet peeve. In my office, I think everybody knows that this is probably one of my pet peeves. Too many times I hear this from clients. Oh, I know about the estate tax. It's something like this. I have to be like a millionaire to worry about it. Or sometimes it goes like this. Oh, I know about the estate tax. It's something like $10 million, right? Or some people go, oh, I know about the estate tax. It's like, I got 10 million, my wife can get 10 million, we can leave 20 million to our kids. We don't have 20 million, I don't need to worry about that. And I would bet that for those of you who raised your hand and said, you know about this, or you've heard of the estate tax, probably you think it's like that too. And I don't blame you, but it's my pet peeve in the sense I think lawyers need to talk and educate people about this. I'll tell you why. The estate tax is a tax that gets paid when I die if I leave too much money to whoever. It could be my kids, it could be to my friends, it could be my brother. They don't care who you're leaving the money to. The point is very simple. When I die, whatever I have gets valued. And what does that mean? My house, my bank accounts, my brokerage accounts, my life insurance. People forget life insurance. My life insurance. Well, life insurance goes to my kids. How is that part of what I own? It is. In the IRS's eyes, when you die, if you're leaving $1 million life insurance policy to your kids, you are worth $1 million more because of that life insurance policy. So they take a snapshot of what you are worth when you die, and they look at literally everything. Okay? If that dollar amount is too high, then there is a 40% tax on anything above that dollar amount. I'm going to give you an example. This is going to make sense. I'm just giving you steps here. So that's the estate tax. It's a federal tax imposed on all U.S. persons when you die, if you die leaving too much in assets. Has nothing to do with a trust. This is for everybody. Okay? There's some exceptions to the estate tax. If one spouse dies first and leaves assets to their surviving spouse, and if that surviving spouse is a US citizen, so if I'm married to a US citizen and I die, and all the assets go to the US citizen spouse, no estate tax at my death. The government will not collect anything at that point. But when my surviving spouse dies and leaves assets to anyone other than a US citizen spouse, kids, siblings, whoever, there may or may not be an estate tax. Okay, so just understand that the first death may be no tax if you're leaving it to a citizen spouse. Second, assets left to others. So if my spouse dies and now leaves it to our kids, you have what's called, and I use easy language, you have a coupon. Okay, that's just my term. You have a coupon. So the coupon changes every year depending on the year of death. And this coupon is courtesy of the US government. So the IRS says, if you die this year in 2023, the coupon is $12.92 million. Okay? That means if I die this year and I'm leaving assets to someone who's not my spouse, not a citizen, not my spouse, let's just say not my spouse, then as long as I'm leaving an amount under my coupon, 12.92 million, no estate tax. But if I leave assets above 12.92 million, there's a 40% tax on the difference. Okay? The problem is, you're going to see, that coupon is not like permanent. It changes every year depending on the year we die. When I started practicing law, the coupon was $675,000 per person. That's it. Today it's 12.92 million. But in the interim, it has gone up and down. And tomorrow it will go up and down. It depends, and I'm not getting political, it depends on who is running Washington. Okay? So if you get a majority, and this is no secret, let's just be open. If you get a Republican president with a fiscally, let's see, I don't use terms anymore, fiscally conservative president and a fiscally conservative Congress that has a majority to 50, let's say 51, I consider majority 51, then the best they can do is raise the estate tax threshold, okay? And if you don't, they're gonna bring down the estate tax threshold. The coupon varies year to year. So right now, we are under the Trump estate tax plan. Under the Trump estate tax plan, it's 12.92 million this year. If you die next year, and there's no change of, we don't know, if there's no change of law from now until next year, it's gonna go up a little bit. The coupon goes up to maybe 13 or 14 million. And in 2025, again, if there's no change in law, it's gonna go up a little bit more with inflation, maybe 15 million. But in 2026, January 1st at midnight, on New Year's Eve of 25, January 1st of 26, the Trump tax plan expires and it resets to Obama estate tax numbers, which were 5 million plus inflation. So you're looking at about 7 million. So it's gonna go from 15 million in 25 to about 7 or 8 million in 26. So you saw the picture of the roulette wheel? It's a roulette wheel. I don't know when we're gonna die. I don't know when I'm gonna die. I don't know what number it's gonna be on. It's a matter of chance to a large degree. But that is how the estate tax works. So when you hear people go, I don't have to worry about the estate tax, you don't know that. It's all dependent on what year you die. Now you might be thinking, well, I can't control that, so what? But you can control it, and that's my point. There is something you actually can do, and probably should look at. By the way, if you're not a US person, they only let you transfer $60,000 tax-free. That's your coupon. That's it. Anyone here not a US citizen? Okay, good. So, I'm going to show you one last thing and then I'll take questions. Here's exactly why I want you to know this. Married couple has $4 million of assets. They have a home, they have some retirement accounts, they have life insurance, okay? They have some assets in the bank or something like that. $4 million collectively. We're in 2023, husband and wife. Okay, now watch what happens. The exemption amount this year is 12.92 million, right? I just told you that. Husband dies this year. What happens? Everything goes to the spouse. Maybe they did a trust, they avoided probate, great. It all goes to the spouse. So now, she's worth $4 million. You follow me so far, right? No estate taxes due. Why? Because she's a U.S. citizen. We call that the unlimited barrel deduction. She's a U.S. citizen, no estate taxes. You follow me, right? Okay. Now, we're gonna kill her in 3 years. This is my terminology, that's how I count, okay? We're gonna kill her off in 3 years when the assets have risen to 7 million. Okay? So her assets will grow to 7 million. She's worth 7 million when she dies. She's now gonna leave assets to who? Her kids, right? Somebody who's not her spouse. And in 2026, I just got finished telling you the exemption is 5 plus inflation. Let's say it's 6 million. Let's just say it's 6 million. What's gonna happen here? She's worth 7, the coupon is worth 6. How much tax?
40% of it.
40% of a million, exactly right. 40% of a million. $40,000 is due in taxes. This could very well be a couple in the room who today says, I don't have to worry about the estate tax, it's $26 million. That is my pet peeve. There's so much misinformation about how people analyze that information. It's 26 million tax-free if me and my wife want to die this year. I don't want to die this year, she doesn't want to die this year. So I gotta stop thinking about it, oh, it's this tax for rich people. In this example, rich is 4 million today. Okay, so it's really important that you understand it. I think a lot of lawyers just skip this part. Could they have planned better? Yes, okay, I'm gonna go back in time. What could they have done? Here's a really easy solution. Something called portability. Your accountants, any accountants in the room? Okay, that means I can say something about accountants. Most accountants don't know this. I cannot understand this, but most accountants do not know what I'm about to tell you. So this is a good place to kind of end the conversation. I gave you a tax tip in the beginning about community property. I'm gonna give you a really good tax tip to end it with estate taxes. So just remember this. Here's something you can do. You can teach your accountant this. When the husband died in 2023, he had a $12.92 million coupon, which effectively, essentially went unused in that example, right? It's like, great, I had 12.92, no, couldn't benefit from it. So let's imagine he dies, he leaves all the money to the wife, she's worth 4 million, but instead of her just going, oh, there's no estate taxes due, who cares? She should do something. And what she should do is not think there's no estate taxes. What she should do is file this thing called a 706 form. No one will ever tell you about it. You may never have heard about it. Consider yourself, you're lucky if this is the first time you're hearing about it. This will save your family a lot of money. I can almost guarantee you that. The spouse should file a tax form called a 706. What that allows her to do, it allows her to pull his 12.92 coupon into her pocket for the rest of her life. So that when she dies 3 years later, when the exemption was 6 million, now it's considered that it's 6 million plus the 12.92 that she pocketed because she filed that form. In other words, her coupon is now almost $19 million. Wow. So guess what? No estate taxes due, just because she filed the tax form when he died. It costs about $5,000 to $10,000 to file this form. It's not a simple form. It's not a DIY, you can do it yourself. You will need an accountant or a tax lawyer or a professional to do it for you. But it's worth it. Okay? It's worth it. So there's a lot more slides that talk about asset protection. I'll just give you a 10-second summary of what that was going to say. It says if you own rental property, if you own a business, you should think of creating entities like LLCs, corporations, so that it protects you from lawsuits. The living trust, while it's very good for probate, and while you can do some neat tax things for your kids, and protect them from divorce and do all of that stuff, what you're not getting out of any of this so far is if you get sued tomorrow, and you go, oh, it's all in my trust, you can't get it. No, they can get it, because you can get it. As long as you can get what's in your trust, your creditor can get what's in your trust. So a lot of people think, oh, I did a trust, if I get sued, they can't get my money. That's not true, okay? As long as you can reach into your trust, they can reach into your trust. So there's two solutions to that. You could do what's called an irrevocable trust, which is very complicated, and we do a lot of those, but it's not for most people. Most people don't need to go that drastic, but you could do an irrevocable trust. The other thing that you could do is create an LLC, especially if you have rental property. And you have a rental property owned by your LLC will be owned by your trust. Nothing goes into probate, and when you get sued, the lawsuit has to go to your LLC, not to you. And the only thing that person can take now, if they sue your LLC, is whatever the LLC owns. So if the LLC only owns that rental property, you are now protecting everything else that's in your wagon. Okay, so that's kind of the long and short of it. If we have time, I can take questions. Mike, what do you suggest?
Definitely questions if anybody has questions, for sure.
It's an easy one. I don't have any money. I've got a condo that, we want to leave our condo for our state when we got it. And, you know, the Howard Jarvis thing, it used to be the inherited, you know, at the same tax rate that we bought it at. But then it changed to like the going rate right now. So is Millville Express, do anything to help that out?
Yeah, so, I think you're talking about property taxes,
Right.
right? Okay, and so Mike can tell you a lot about this as well. But, the current state of the law in California is that the property, as a general rule, when I die and property goes to my kids, the kids will have to pay property tax at fair market value. So if I bought a condo for $100,000, but by the time I died it was worth $500,000, unfortunately, the kids are gonna have to pay property tax as though they purchased the condo at $500,000, which was 1% of $500,000. So they're gonna pay a lot more in property taxes. Can a trust avoid it? Yes and no. The easier way to avoid it is the law allows for one exception, is that if one of your children lives in the home after I die and claims it as their primary residence, then there is a narrow exception in which they may be able to keep your property tax.
Actually, one of my kids, he's 29, he'll be 30, but he does it. My daughter just called me up. I mean, it's Costco, she's, and it's okay, thanks.
Sure, yeah, you're
Hey,
welcome.
thanks for everything, I'm gonna keep your card. I learned a lot.
Great.
I wish I was happy about it.
Well, I'm glad you learned a lot, yeah.
Four children, 40, 28, so I left them upon my death to get what they're supposed to get. 21 years,
Maybe I'll just take a
want
picture,
them
then I'm
to wait
getting
to 2035 because of there's a trouble explaining. How do they get protected from inflation? What happens to that money for them?
Yeah, so,
The one more part, I've seen it on TV where a silly guy is saying, he's trying to borrow against his trust. How do you prevent that? Where I guess he signs the trust over something else. And then he gets some sort of discount with his money. You know what I mean?
okay, so there's two questions. Question one is, if you have a situation where you have a trust, you have multiple children, but you want your children to inherit at different times in their lives, how does that work? So the answer to that question is pretty simple. We do this all the time. The trust will say, child one, you can get your inheritance however you want, immediately or in a trust, etc. But for those children who we want them to become older, what will happen is you will name in your trust somebody. We call this a successor trustee. We will have you name who is the person who, on behalf of that child, can manage that child's share. And so, for example, if I have, say, 2 kids, And both of them, I don't want them to be in control of it just yet. I might name my brother, and I go, you are gonna manage my kid's trust individually, independently. So this trust is for this kid, and this trust is for this kid. This trust says this kid can get it when they're 35, this trust says this kid can get it when they're 31. You, brother, are gonna manage this for me when I'm gone for the kids. But when this kid turns 35, you're out. And when this kid turns 31, you're out. So it can all be written in the trust. The second, and we do that all. The second question is, I think I understand the question. Like, there are people who say that you can like do all these fancy things like borrow from your trust or loan to your trust, or take what's called discount values. I will say, I think two quick answers. One is there's a large part of that which I actually don't know, because there's all kinds of weird things out there which I would stay far away from. So to some extent, it could be that. But the second part of that answer is discount values are something that we use for irrevocable trusts. So people create irrevocable trusts. It's trust where you go, I'm gonna put my assets in this trust. The motivation is not to avoid probate. In an irrevocable trust, there's a different motivation. Because if all you want to do is avoid probate, you put it in a trust that you can control. Why would you give up control, right? I want to keep control, I want to avoid probate. I want the best of both worlds. An irrevocable trust, though, it's not about beating probate. It's saying, I want to save on taxes. I have huge estate taxes, or I pay too much income taxes in California. Or I want to protect myself in the case of a lawsuit. But if I put it in a living trust, it's tax neutral. It's asset protection neutral. It's not going to protect me if I'm sued. It's not going to save me on taxes. It's not going to hurt me. It's kind of neutral. But where you want to save on taxes or you want to protect yourself from lawsuits, you might consider creating an irrevocable trust. Now, they're expensive and they come with a whole list of catches. But if it still makes sense, there is something called discount values. And the trust is treated as a separate entity. It's not you, it's separate and apart from you. So it pays a different tax rate. If you get sued, they can't come after those assets because it's not yours, it's separate. And in that scenario, you can loan and borrow money between you and the trust because the trust is entirely separate from you.
I mean, there's a commercial out there, there's geeky guys saying, I want my money now. And, J.G. Wentworth. and it looks like he's borrowing against, it sounds like he's borrowing against a trust.
I don't know about that. I don't know about that.
So there's an individual that has a trust, but they've been the beneficiary, and the trustee that wrote the trust is long gone. And this individual has had the trust for 25 years and has no durable power of attorney, has no health directives, has nothing except the trust and personal assets. Going through probate, right? Absolutely. If there's no other mentioned individual other than the trust.
Just to recap that question.
Sure.
Say a parent passes away,
Right.
leaves assets in a trust to
Child, only single child.
a child, and the assets are still in the trust.
Absolutely. The greatest preponderance, 70% to 80% in the trust.
Okay, and the rest of the assets are
Personally owned,
by the child.
yes.
Okay, so the first question I have is, if the parent or parents have all passed away,
Yes.
usually, and it depends on how the trust is written, usually the assets should have emptied out of the trust and the trust should be terminated. But let's say for whatever reason, the trust says, no, it's gonna stay on and on for the benefit of this child.
Right.
So far, I have no problem because as long as the assets are titled in the name of the trust,
Right.
when that child dies, the trust should indicate who it's gonna go to next.
But there's nothing in the trust that says that.
Then that's a problem.
That's a problem.
Yeah.
So unlike a will, which would have a codicil, this is just, there has to be another trust generated. That trust, that should be closed and another one completely reinstituted, correct?
which is, again, where I started, usually the assets are gonna be emptied out of the trust is terminated, it goes to the child takes it, the child puts it in their trust, and they get to decide who gets it.
And that should have all those, the three things that you mentioned, the house
Yeah.
direct gives those.
Yeah, and again, those are separate and apart from the trust, but it's just like, the trust is good to avoid probate, the trust is good to make sure you give it to who you want it to, how you want it to get. Incapacity documents or other things, yeah, and you should probably do all of them together, or that person should.
Thank you, great job.
There are cookies that have been baked in the back by Lena, who's an excellent, excellent baker, and so you guys should really try it if you haven't.
There's no calories in them though?
I don't know, but I'm gonna get them. All right, thanks again for attending, and if you have any questions, we're here to talk.